before they could be distributed as best to subserve the common good. Since those material resources which belonged to the state only could be distributed by the state, Sri Sen argued that material resources had first to be acquired by the state before they could be distributed. A law providing for acquisition was not a law for distribution. We are unable to appreciate the submission of Sri Sen. The expression material resources of the community means all things which are capable of producing wealth for the community. There is no warrant for interpreting the expression in so narrow a fashion as suggested by Sri Sen and confine it to public-owned material resources and exclude private-owned material resources. Thereafter, if your lordships comes to the next page, same para 19 in continuation, the 6th or 7th line from the top. When Article 39B refers to material resources of the community, it does not refer only to resources owned by the community as a whole, but it refers also to resources owned by individual members of the community. Resources of the community do not mean public resources only, but include private resources as well. Nor do we understand the word distribute to be used in Article 39B in the limited sense in which Sri Sen wants us to say it. It is used, that is, in the sense only of retail distribution to individuals. It is used in a wider sense so as to take in all manner and method of distribution, such as distribution between regions, distribution between industries, distribution between classes, and distribution between public, private, and joint sectors. The distribution envisaged by Article 39B necessarily takes within its stride the transformation of wealth from private ownership into public ownership and is not confined to that which is already public owned. And this is important, your lordships. The submissions of Sri Sen are well answered by the observations of Justice Krishna Iyer. And then paras 80 and 82 said that so the submission is that there has to first be an acquisition of the property because 39B deals only and only with distribution. It cannot be used in aid of statutes where the property of a private individual is being acquired.
Actually, Ms. Shukla, the philosophical approach of both Justice Krishna Iyer and Justice Chinnappa Reddy is this. If you look at the purely capitalist concept of property, the capitalist concept of property attributes a sense of exclusiveness to property. This is my pen. It's exclusively mine. Nobody else can use my pen. The socialist concept of property is the mirror image which attributes to property a notion of commonality. Nothing is exclusive to the individual. All property is common to the community. That's the extreme socialist view. Our directive principles, we must understand, have their foundation in the Gandhian ethos. The directive principles are really in pursuance of the Gandhian ideology. And what is that ethos? Our ethos regards property as something which is held in trust. We don't go as far as to adopt the socialistic model that there is no private property at all. Of course, we have private property. And that concept of trust, which is now being applied, in the context of, say, sustainable development, in the environmental context. Maybe it's in my mind because I was teaching a class this morning on sustainable development and climate change. But, our concept of property has undergone a very subtle change from either the extreme capitalist perspective or the extreme socialist perspective. We regard property as something which we hold in trust. We hold the property in trust for the succeeding generations in the family. But broadly, we also hold that property in trust for the wider community. That's the whole concept of sustainable development. That property which we have today, as today's generation, we hold in trust for the future of our society. That's what you call as intergenerational equity. Right?
Yes.
So, it would be, to my mind, it would be a little dangerous to have this dichotomy that 39B only. Now, one more thing before I come to it, because I'm sorry to break your link, but I'm getting old and I might miss this, half an hour later. Both Justice Krishna Iyer and Justice Chinnappa Reddy deal with two aspects when they deal with 39B, the origin and the beneficiary. the argument before the bench in Ranganath Reddy was that the origin must be in the community for 39B and C to apply. If something does not originate in the community, then 39B can never apply. Second argument was that distribution postulates that you will distribute it to individuals. If you're not distributing it to individuals, then 39B will not apply. They deal with both these arguments at a philosophical level by saying that even if something does not originate in the community, right, if it is property of the nature which has a bearing on the welfare of the community, 39B is capable of application. Second, that is the origin. On the distribution, they say that even if it is not being distributed to individuals, for instance, nationalization, you take over property, vest it in a state corporation. It's not a distribution to an individual. That concept is also within the purview of 39B. Because why were you nationalizing? You were taking over private property, but using that property for interest for the wider society, but it is not being given, it's not being distributed. So they deal both with the source or the origin, and they deal with the distribution aspects in these two judgments. It may be a little extreme to suggest that material resources of the community only means resources we do not have their origin in the private property of an individual. I'll tell you why it will be dangerous to take that view. Take simple things like mines, forests, even private forests. For us to, for instance, say that, look, the moment a forest is a private forest, 39B will not apply, would be, and therefore it's hands off, would be extremely dangerous a proposition. It depends upon context. As Brother Dulia said yesterday to us when we were discussing on the bench, it depends on the context. In a given case, a private house.
Zamindari land.
Yeah, exactly. Zamindari lands. That was the whole basis of our agricultural ceiling laws, yes. Whether it was the UPZA and LR Act or the Maharashtra Agricultural Ceiling on yes. Agricultural Lands Act. So we must have regard to, we must put ourselves back in the 1950s when the Constitution was made. So the Constitution which was intended to bring about a sense of social transformation. And that was the transformative ideal of the Constitution. Whether this act is valid is a completely different issue.
Yes.
Is a completely different issue. That will ultimately be decided. But we can't say that 39B has no application once property is privately held property. Because the societal demands, the societal welfare, the need for redistribution, considering the societal perspective. So it may be airwaves, it may be water, it may be forests, it may be mines. In some areas, probably the dividing line becomes very clear. Just taking somebody's flat. Possibly, you may have a point on that. But we must understand that 39B has been crafted in a certain constitutional ethos. That the Constitution was intended to bring about a social transformation. We shouldn't therefore go as far as to say that the moment private property is private property, that 39B and C will have no application.
So, Lordships, may I just...
The second thing which I wanted to tell you was that whether 39B and C can have two consequences in our constitutional law, right? One, the moment a law is enacted to give effect to 39B and C, that law is immune from challenge under Article 31C, unless you come to the conclusion that the law has no nexus to 39B and C, which was what was struck down in Keshwan Bharati. So the moment a law is in furtherance of 39B and C, that law has an immunity under 31C. But even if the law does not have an immunity under 31C, right? Even if the law is not immune from 31C for some reason, say some bench comes to a conclusion that 31C does not exist on the statute book today. Even so, the fact that the law has been made in pursuance of 39B and C may be an index of its reasonableness. And that's not just 39B and C. The fact that Parliament or the state legislature has enacted a law to give effect to any of the possibly, you may have a point on that. But we we must understand that 39B has been crafted in a certain constitutional ethos, that the Constitution was intended to bring about a social transformation. Therefore, we shouldn't therefore go as far as to say that the moment private property is private property, that 39B and C will have no application.
So, Lordships, may I just...
The second thing which I wanted to tell you was that whether 39B and C can have two consequences in our constitutional law, right? One, the moment a law is enacted to give effect to 39B and C, that law is immune from challenge under Article 31C, unless you come to the conclusion that the law has no nexus to 39B and C, which was what was struck down in Keshwan Bharati. So the moment a law is in furtherance of 39B and C, that law has an immunity under 31C. But even if the law does not have an immunity under 31C, right? Even if the law is not immune from 31C for some reason, say some bench comes to a conclusion that 31C does not exist on the statute book today. Even so, the fact that the law has been made in pursuance of 39B and C may be an index of its reasonableness. That's not just 39B and C. The fact that Parliament or the state legislature has enacted a law to give effect to any of the directive principles is an index of its reasonableness. But reasonableness postulates that it's subject to or amenable to judicial review. What 31C did was, it completely excluded from judicial review on grounds of 14 and 19,
Yes.
leaving open again now other constitutional challenges.
Right.
So I think that's where the matter really lies in that sense.
So, Lordships, I'll just...
Today, Mr. Andarjuna didn't argue on 31C. We'll ask the other side when we are on 31C, because, you know, one thing which we are thinking aloud, actually, not just for you, but for the other side when they take up their view. The argument that this law has no nexus to 39B and C, right, postulates that 31C is valid, because that whole argument that the law on your side, that the law has no nexus to 39B and C, postulates that because it has no nexus to 39B and C, therefore the law is not protected by 31C.
Yes.
Which means that 31C is there.
Exactly.
But because the law has no nexus to 39B and C, therefore this law is bad.
Yes.
Right? But if 31C does not exist at all.
Absolutely.
Right?
Yes.
Then the 39B and C argument will still apply.
But independent of 31C. Yes.
On the ground that the law is not immune from challenge under Article 14 and 19.
Exactly.
But the law is presumed to be reasonable because it is giving effect to 39B and C. There are two different things. One is an immunity from constitutional challenge. The other is the index of the reasonableness of the law.
Absolutely.
So I'm subject to hearing the other side. Now, one last thing, Mr. Attorney, Mr. Solicitor and Mr. Dwivedi, look at it this way. The 31C argument, the 31C argument, there are succeeding constitutional bench judgments of our court which have taken the view that 31C still continues to exist. Minerva takes it, Vamanarao takes it, subsequent decisions have taken it, though Mr. Nariman argued in the referral order that this was only on a concession.
Yes.
This was on a concession.
Yes.
Now, therefore, that 5, the correctness of the Constitution bench implicitly holding that 31C still continues to be on the Constitution, the correctness of it, if it has to be tested, which was what Mr. Nariman argued, will have to go to 7. We'll have to go to 7 judges. 9, the reference to 9 came only because of Ranganath Reddy, Justice Krishna's judgment, which was then adopted in Sanjeev Coke. Therefore, the bench felt, let's go to 9.
Yes.
But even if we don't go into 31C, 31C will have to be decided. Whether 31C is on the statute book will have to be decided by a bench of 7 judges.
Yes, absolutely.
Now, the question is whether we should leave it for a future day for some 7-judge bench to decide it, or decide it here, because we are certainly a bench of 9 can certainly decide it. Why leave the law in a state of uncertainty?
On our side, speaking for myself,
down the line for this court to say that 31C does not exist will be a very radical constitutional consequence. So all the laws which have been protected under 31C